Hello, this is Richard Barid. I'm an estate planning and elder law attorney here with Smith Barrett LLC. And today I wanted to talk with you about some basic things you can do to provide for your spouse through your estate planning. So here we're talking about basic estate planning. For most people, that means a will, power of attorney, a healthcare directive, a HIPAA authorization, or sometimes a trust, what's called a living trust or a revocable living trust. So at the heart of your plan, or what we consider the hub of the wheel, the hub of your plan will be either a will or a revocable living trust. If we use a revocable living trust instead of a will, we can avoid probate, or that means the people we leave behind. Here we're concerned about a spouse. If we're leaving a spouse behind, it will be easier for that spouse to regain or to continue control of the assets that you've worked so hard to put together without any government intrusion, without any interference from the probate court. You can do that with a revocable living trust. We've got lots of resources on the webpage to tell you more about how that works, or we're happy to talk to you about it in person. Some folks don't want to do things that way. They'd rather go with a will, and a will does require probate, but it is still a time-tested way to pass your assets along to your spouse. And if your spouse doesn't need them or is no longer with us, they can go to your next level of beneficiary, so often the kids or the grandkids. So at the base of it, we need a will or a trust, a revocable living trust, and from there, it's important for everyone to have, any adult who's competent, to have a power of attorney. And it's what you think it is. We call it a general durable power of attorney. It's a document that gives very broad range of control, and you can customize that range of control on the standard Georgia power of attorney form. But it's a document that you execute while you're competent, saying if at some point I am unable because of physical limitations or medical treatment or incapacity, if I cannot for whatever reason run my own day-to-day personal business, my own financial affairs, this is the person that I'm nominating and putting in charge, and you can have successors to that person. So usually we would name a spouse first if everyone is healthy, and then from there maybe it's one of the kids, maybe it's a sibling, maybe it's a parent, depending on what your age is, and you put that person in as a successor trustee, or rather a successor power of attorney agent. And that way, if and when you become incapacitated, there doesn't have to be this interaction with the probate court where we're talking about a guardianship and a conservatorship to be able to control your health and welfare and your financial resources for your own benefit. A lot of times we can avoid that, which is both expensive and time consuming. We can avoid that court process with a basic power of attorney. So we want to make sure everyone has that. So a will or a revocable living trust and a power of attorney, an advance directive for healthcare, a healthcare directive. What we used to do in Georgia anyway was we had a power of attorney for healthcare, a healthcare power of attorney, and a living will. The healthcare power of attorney said, this is who I want to be in charge of my medical decisions, and then the living will would give that person some guidance as to what we want with respect to long-term care, with respect to life-sustaining treatment, and other variables that have to do with your healthcare if you can't make and communicate the decision yourself. Very important to have an advance directive for healthcare. So instead of a healthcare power of attorney and a separate healthcare living will, instead of that, we would have one document, which is the advance directive for healthcare. It's a standard Georgia form. Other states have similar forms. And what you do is you work with an estate planning attorney or someone experienced in estate planning, and they will walk you through that form where you can indicate your preferences about things like organ donation, body donation, life-sustaining treatment. So if I get to a point where I can't communicate for myself, a very sad situation like maybe the Terry Schiavo situation some years ago, well, is the family going to keep you alive even though there's no hope of recovery, or would you rather be let go peacefully, maybe with some pain management, but not life-sustaining treatment, if at least two physicians working independently say that whatever your condition is, a permanent state of unconsciousness, a terminal condition, that there's nothing else that can be done. You can hold out for a miracle, which some people do, and certainly that happens medically sometimes. You can just say in your advance directive that what I want is to pull out all the stops. So do everything possible to keep me alive, and God is going to pull me through, or whatever your beliefs are, I want everything possible done to keep me alive. Or you can make 180 degrees the opposite decision, which is, I don't want any life-sustaining treatment at all. I want to be kept comfortable with pain medication. I want to be fed and taken care of, but I don't want there to be any heroic measures taken. I would rather be let go on my way and not have to live like that for a long time. Or you could do some combination. You could pick and choose to an extent what sort of care you want and what sort of care you don't want. So maybe you say, I want a feeding tube and hydration by tube or IV, but I don't want CPR. I don't want any sort of life-sustaining treatment if I'm going to pass away anyway. I don't want a respirator, that sort of thing. It's important that you make those decisions, communicate those decisions with your attorney, put those decisions down on paper in the form of an advance directive. That way your loved one still has a difficult job, and that is communicating your wishes with respect to life-sustaining treatment, but at least they don't have to make the decisions. And from talking to our clients, we know there is an emotional difference between communicating the wishes, which is not easy, communicating what your wishes are with respect to life-sustaining treatment to the doctor, versus having to make the decision to, quote, pull the plug, is the way a lot of people think of it. We understand that is a lot more emotionally burdensome than simply having to communicate the wishes that mom and dad or you or whoever it was made in their own advance directive to direct what kind of care we have. So the person doesn't have to carry the emotional burden of making that decision themselves. So that's a really important feature, and you get that through an advance directive. You might also want to include a HIPAA authorization. It's a law that went into effect in 1996, and among many other things, it provides for a sort of a tight clamp down on medical and healthcare information. The healthcare providers, the doctors, the nurses, or anyone who has that information can't communicate your healthcare information without your permission. You may have noticed for the last several years, when you go in to see a doctor, you're signing a whole bunch of waivers because the doctors, even to send information that's your health information to another doctor, maybe a specialist, they have to have your permission to do that. So what we're talking about putting together is a sort of a blanket HIPAA authorization saying this list of people. So maybe it's a small list, maybe it's just your spouse and your 2 kids. These people can have access to my healthcare information even if I'm not conscious or able for whatever reason to provide the consent. I'm telling you now in this HIPAA authorization, I want the information shared with them. So if they live far away and they have to call the doctor, the hospital, the nurse, and find out what's going on, they're able to do that instead of the nurse or the doctor or whoever the healthcare provider is having to say, I'm sorry, this is protected health information under HIPAA and I can't tell you anything. This sort of a release breaks through that barrier and keeps everybody informed about your health situation. So these are some very basic things that you can do, having nothing to do yet with Medicaid planning or VA benefits planning or even long-term care planning. This is really the basics of what anyone ought to do if they have a spouse in order to protect their spouse and make things as easy as possible in what may be a very difficult situation if you become incapacitated or certainly when you pass away. If you have questions, please give us a call or contact us through the website. Again, my name is Richard Barid with Smith Barid LLC. Thanks for joining me today.
I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now, we're posting 3 videos a week with lots of information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click right over here to watch the next most relevant video about estate planning. Go watch it now.